Exam Scholar, Real Estate Edition.
Question 1. Which of the following best describes a complete escrow? A. It is considered a perfect escrow. B. The escrow holder has ceased being an agent for both parties. C. All papers are properly drawn up and ready for final steps to be taken to close the escrow. D. All services of the escrow holder are involved. Answer. C. The settlement in choice C describes a complete escrow. Usually an escrow is complete in the evening and closes the following morning when the deed is recorded. Question 2. When a legal description uses only sections, townships and ranges, the lines relate to the A. Government survey lines. B. Contour lines. C. Recorded tract map. D. Meets and bounds descriptions. Answer. A. Sections, townships and ranges are used in government surveys in describing the location of land. Meets and bounds description outlines a certain area. Question 3. A lender would be exempt from the requirement of providing the borrower with a federal right to rescind notice except A. If the loan is for more than $25,000 and is not secured by the borrower's personal residence. B. If security for the loan is commercial property.
C. If the loan is for business expansion.
D. If the borrower is refinancing. Answer. D. A negative question. Refinancing your personal residence is not an exemption and is fully covered by a 3-day right of rescission. Question 4. Fisk owns a lot. He also owns a right-of-way easement over the property of his neighbor, Smith. This easement is appurtenant to Fisk's lot. Fisk sells his lot to Jones without specific mention of the easement in the deed. The easement A. Remains with Fish as an encumbered interest. B. Passes to Jones. C. Terminates unless it is a covenant running with the land. D. Reverts to Smith. Answer. B. Appurtenant easements run with the land and automatically pass to future grantees, whether mentioned in the deed or not. Question 5. Which of the following would normally install conduit? A. Plumbers. B. Electricians. C. Roofers. D. Carpenters. Answer. B. Electrical wiring is placed inside a metal pipe called a conduit. Question 6. Two people entered into a land contract for the purchase of a home and the contract was recorded. A few months later, the vendee abandons the property and defaults on the contract. If the vendee refuses to execute and record some form of release, it will A. Not affect the marketability of the property. B. Result in a deficiency judgment. C. Result in a trustee's sale. D. Create a cloud on the title. Answer. D. A recorded land contract show an equitable interest in the property. When the vendee, buyer, defaults and abandons the property, the land contract becomes a cloud on the title until it is removed by either a quitclaim deed or a quiet title action. Question 7. A broker who is hired by an owner to sell his property must reveal all significant and material information to the principal. Which of the following would be considered material information and must be revealed? A. The new lender will require the buyer to maintain an impound account. B. Agent's knowledge that a better offer to purchase is imminent. C. The prospective buyer is of Oriental descent. D. None of the above. Answer. B. The existence of a better offer that is imminent could very well be a material fact to the seller. It would probably influence his decision on a present offer. Question 8. Generally, The most important determinant of a property's value is A. Age. B. Utility. C. Location. D. Income. Answer. C. Location is the most important factor influencing value, the other factors being utility, size, shape, thoroughfare conditions, exposure, character of the business climate, plottage or assemblage, character of the soil, grades, obsolescence, building restrictions and zones. Question 9. Real property includes the land, those things attached to the land, and thing called appurtenances. Appurtenances include all of the following except A. A dwelling. B. Trade fixtures. C. Watercourses. D. A fence. Answer. B. Trade fixtures are considered personal property. Question 10. How many acres are in the west half of the south half of the south half of the south half of section 27? A. 20 acres. B. 40 acres. C. 80 acres. D. 160 acres. Answer. B. Section 27 equals 640 acres. S half equals 320 acres. S half equals 160 acres. S half equals 80 acres. W half equals 40 acres. Question 1. Which of the following items is usually considered to be a cost of home ownership? A. Land depreciation. B. Improvement appreciation. C. Amenity value. D. Interest lost on the owner's equity. Answer. D. The interest that is lost on owner's equity is usually identified as lock-in equity. This term applies to the fact that the owner cannot utilize the funds for other investment purposes. Question 2. Abel submitted an offer to purchase Blackacre. During the escrow period, a local credit reporting agency submitted detrimental information which Abel contested. Abel made repeated attempts to get the matter corrected and he was denied access to the information reported to the agency. Abel may A. Bring an action to recover punitive damages of no more than $5,000. B. Bring an action in a court of appropriate jurisdiction to recover actual damages. C. After a prescribed time, require the reporting agency to delete such information from the report. D. All of the above. Answer. D. All choices are open to the principal in question. Question 3. Mr. O'Reilly paid an owner $10 for an option containing this clause, option to be for 60 days from June 1, 1967. Upon exercise of option, holder is to purchase within 30 days thereafter for all cash consideration. On July 10, Mr. O'Reilly sold and assigned his option for $1,000. On July 28, the new holder notified the owner that he would purchase on August 15. The owner claimed the option was void. The option was A. Void, because the holder sold it. B. Void, because date of purchase was not within the option period. C. Valid, even though Mr. O'Reilly sold it, but August 15 was too late for date of sale. D. Valid, and assignee could purchase on August 15. Answer. D. Inasmuch as the terms of the option are for all cash consideration and no unsecured promissory note is involved, it must be sold or assigned, because the new holder exercised the option within the 60 days period, before July 30, and purchased the property with 30 days of the exercise date, before August 30, the option is valid. Question 4. Other than non-dischargeable debts of a bankrupt debtor are cut off, discharged. A. Publication of the notice of the petition in bankruptcy. B. Discharge in bankruptcy. C. The first meeting of creditors. D. Filing the petition in bankruptcy. Answer. B. Debts are cut off, discharged, the date bankruptcy court issues a discharge. Question 5. In which of the following ways may an agency relationship not be created? A. Verbal authority. B. Necessity or emergency. C. Post hoc ratification. D. Subordination. Answer. D. Subordination means lie, trickery or deceit, hence, it cannot be a valid way to create an agency. Question 6. A person and his property that is encumbered by a first deed of trust are in Chapter 7 bankruptcy. The court can sell the property and use the proceeds therefrom to pay debts owed to unsecured creditors. B. Holder of the first deed can foreclose. C. Debtor need not make payment on the promissory note secured by the first deed of trust. D. Debtor can sell the property. Answer. A Chapter 7 bankruptcy petition creates an automatic stay of a creditor's foreclosure against the debtor. Creditor must file a petition with the bankruptcy court seeking relief from the automatic stay and approval to institute foreclosure action. If the note is oversecured by collateral, the bankruptcy court trustee may sell the property, pay the secured creditor, and use the excess proceeds to pay unsecured creditors. If the debtor does not make payments on the note during the automatic stay, the bankruptcy trustee will pay interest to the secured creditor from the date of petition to the date of sale. Question 7. A loan that is secured on easy terms and with a low down payment usually results in A. Increased financing costs. B. Decreased financing costs. C. No difference in financing costs. D. Faster amortization. Answer. A. The lender is not going to be given easy terms or long-term financing without securing something in return. This usually results in increased financing costs. Question 8. Insofar as a residential neighborhood is concerned, which of the following would offer the least protection against blighting influences on future development? A. Natural or artificial barriers. B. Partially built-up neighborhood. C. New neighborhood in the path of directional city growth. D. All families with similar income. Answer. B. A partially built-up neighborhood would have a definite tendency for blighting, because it was not completed and there would be a potential for vandalism. Question 9. In negotiating certain loans, a broker is required to fill in all of the items on a broker's loan statement form. The following item must be inserted. A. What the borrower intends to do with the proceeds of the loan, less expenses. B. A statement of the value of the property supported by a proper appraisal. C. The date on which the borrower acquired the property. D. The amount that will be charged by a qualified agency to render a report on the financial capacity of the borrower. Answer. D. The loan broker law requires, among other things, that the broker's loan statement contain estimated costs including appraisal, escrow, title, notary, recording and credit investigation. Question 10. Which of the following is not a characteristic of an easement? A. It is an interest which can be protected against interference by third persons.
B. S pause. Second equals 0.80 pause. It is capable of being created by a conveyance.
C. It is considered a non-possessory interest. D. It is an interest that can be terminated at will by the possessor of the land. Answer. D. The possessor of the land is the owner of the land. He cannot terminate the easement at will. Question 1.
M A I S I R R N M I E M and F C I are affiliated with A C A R B D R E C D A R D N A R. Answer: D N A R is the National Association of Realtors. NAR has 9 affiliated institutes, societies and councils, including the American Institute of Real Estate Appraisers, M.A.I., Member Appraisal Institute, the Society of Industrial Realtors, S.I.R., Realtors National Marketing Institute, R.N.M.I., Institute of Real Estate Management, I.R.E.M., and the Farm and Land Institute, F.L.I.
Question 2. The 2 characteristics that have the most impact on the market value of land are: A. Uniqueness and immobility. B. Improvement and indestructibility. C. Demographics and construction costs. D. Scarcity and permanence of investment. Answer: A. No 2 properties are exactly alike, and land can't be moved from place to place to respond either to supply or demand. This uniqueness, sometimes called situs, and immobility can cause supply to fall short of demand and so increase property prices. The real estate market is said to be inflexible, slow to respond to changes in supply and demand. This is largely because of land's immobility and the length of time required to develop properties to meet suddenly increased demand. Question 3. If there is no special agreement to the contrary, the mortgage usually having priority is the one: A. For the greatest amount of money. B. That is a construction loan. C. That is recorded first. D. That is executed and delivered first. Answer: C. A mortgage or trust deed priority is established by recording. Question 4. Broker-able procures a lessee for a lessor for a 5-year lease agreement. The usual method of compensation would be: A. A flat fee. B. A percentage of the first year rent. C. A percentage of the total lease paid in one lump sum. D. A percentage of the total lease to be paid monthly or annually. Answer: D. On longer-term leases, the agent is entitled to their compensation on the total or full amount of the lease, but the compensation is usually paid each month over the life of the lease on shorter terms and for the first few years on the extremely long-term leases. Question 5. Assume a broker sells a house built by a subdivider and title is passed by a grant deed. Under usual procedures, which of the following will be obtained from the beneficiary under an existing blanket deed of trust? A. A grant deed. B. A quitclaim deed. C. A partial reconveyance. D. A warranty deed. Answer: C. The beneficiary will give a partial reconveyance deed reconveying that one lot. Question 6. To avoid litigation between a principal and a broker, it is best to have: A. A written contract stating the statutory commission rate. B. A written contract. C. An oral agreement. D. A contract established by estoppel. Answer: B. The best way to avoid litigation is to have a written contract. Where there is a writing, it often prevents a lawsuit. Answer 1 states that you should have a written contract stating the statutory commission rate, which is an unlawful statement. Real estate laws prohibit agents from stating that the commission is established by statute. The listing form must have a 10-point type that commissions are negotiable. They are not set by statute. Question 7. A mortgage that was executed 2 years ago provided for a prepayment penalty. The mortgagee is most likely to waive this penalty when A. The supply of money exceeds the demand. B. Deflation is the trend and low interest rates are common. C. A new loan can be made on the property at a higher rate. D. Building costs are rising substantially. Answer. C. The lender charges a prepayment penalty because of the loss of interest resulting from the early payoff of the debt. A new loan, at a higher interest rate on the same property, would make up for the loss of interest on the loan that was prepaid. Question 8. An ad offering secured loans for sale would be regarded as misleading unless A. The ad was placed by a licensed loan broker. B. Each purchaser was offered a standard title insurance policy covering the encumbered properties. C. The broker secured the borrower's signature on the loan broker statement. D. The ad fully explained how and to what extent the funds would be secured. Answer. D. An ad offering a secured loan must disclose how and to what extent the loan is secured. Question 9. A trustor defaults on his loan and refuses to reinstate the deed of trust. The most expedient thing for the beneficiary to do is to institute A. Sheriff's sale. B. Lien sale. C. Trustee's sale. D. Judicial foreclosure. Answer. C. A trustee's sale would be the recommended procedure when there has been a default on a trust deed. It has many advantages over a judicial foreclosure. Question 10. Real estate generally includes all the following except A. Trees. B. Air rights. C. Annual crops. D. Mineral rights. Answer. C. Common law treats annual crops, those that must be planted each year, as the personal property of the one who planted and tended them. When a farm is sold, trees, air rights, and mineral rights may all convey, but the annual crops, fructus industrialis, or emblements, lacking effective contractual agreement to the contrary, are still the personal property of the tenant farmer or other person who planted them. The farmer may return and harvest them in season. Question 1. Commissions of a licensed real estate broker specializing in property management are A. Based on the first year's rent. B. Based on a percentage of the gross rents collected. C. Based on a percentage of the rents expected to be collected over the life of the leases. D. Equal to the first and last month's rent. Answer. B. Commissions are usually based on a percentage of the gross rents collected, not those expected over the life of the leases. Question 2. An interest in real property can be acquired through adverse possession or by prescription. The interest acquired by prescription is A. The right to use the land of another. B. An equitable title. C. A legal title. D. A private grant. Answer. A. Prescription refers to an easement, which is the right to use the property of another. Question 3. In imposing restrictions on a new large subdivision, the most practical method is to A. Record the restrictions in the manner provided by law and make reference to them in each deed. B. Publish the restrictions in a newspaper of general circulation. C. Post the restrictions on the property. D. Post the restrictions as covenants in all the deeds. Answer. A. It is impractical to place the restrictions in each deed since there are usually a great number of restrictions. It is better to record the restrictions and make reference to them in each deed. Question 4. A broker receives an offer on a property and a prospective purchaser gives him a $1,000 deposit. He places the deposit in his trust account. After all the conditions of the deposit receipt have been fulfilled, the buyer decides that he wants to back out. A. Give the $1,000 to the seller. B. Give the $1,000 to the buyer. C. Keep the $1,000 in his trust account. D. None of the above. Answer. The deposit belongs to the seller, once the conditions of the deposit receipt have been fulfilled. Question 5. When a developer sets up a subdivision, he places certain restrictions on each of the lots. Of these, experience has shown which of the following is least likely to be enforced. A. Limitations on size of each lot. B. Limitations on the dollars allowed for improvements on each lot. C. Limitations on square footage of each home. D. Limitations on the number of stories or total height of structures. Answer. B. Limitations for the amount of dollars allowed for the improvements on each lot is the most difficult type of restriction to enforce, because the value of the dollar changes and thus, the quality of the improvements would change. Question 6. The Hutchinsons, prospective buyers of a home, request a broker to find a loan for them. He would mostly likely contact A. An institution lender, such as bank or savings and loan association. B. A Federal Reserve Bank. C. The Federal Housing Administration. D. An FHA appraiser. Answer. An institutional lender is more likely to be advancing the funds towards the purchase of a home. The Federal Housing Administration and the Federal Reserve Bank are not lenders in the home loan market. Question 7. Mortgages and trust deeds differ in all of the following ways, except A. Parties. B. Securities. C. Statute of limitations. D. Title. Answer. B. A mortgage and a trust deed are security interests in property. They provide the legal title to have the property sold in the event that the borrower defaults. Question 8. After 6 lots have been sold in subdivision, the real estate commissioner was informed of misrepresentation in the sales program. The commissioner could halt the sale of more lots by A. Voiding the public report. B. Attaching the unsold lots. C. Issuing a desist and refrain order. D. Filing an accusation in court. Answer. C. The best course of action available to the commissioner would be a desist and refrain order. Such an action would immediately halt all future sales for marketing of the property. Question 9. A subordination clause in a trust deed benefits A. The beneficiary. B. The trustor. C. The trustee. D. None of the above. Answer. B. A subordination clause allows the trustor to obtain a later trust deed which will move into prior position, as regards to payment, in case of default. It is to the trustor's advantage, not to the beneficiaries. Question 10. An agency relationship can be established by all of the following, except A. Agent volunteering. B. Oral agreement. C. Implied statement of law. D. Agreement of principle. Answer. A. An agent cannot volunteer to be your agent. An agency can be established by an agreement with the principal. It can be implied, by your acts, the principal accepts your agency. It can be an oral agreement. Agency does not have to be in writing, but the commission agreement must be in writing. Question 1. Which of the following is not a way in which mortgages and trust deeds differ? A. Securities. B. Title. C. Statute of limitations. D. Parties. Answer. A. They are both security interests in property. They provide the legal right to have the property sold in the event that the borrower defaults. Question 2. The statutory dedication process is completed when A. The appointed representative of the city or county signs accepting the dedication. B. The final subdivision map is recorded. C. The dedicated area is completed. D. Local authorities deliver a signed acceptance to the subdivider. Answer. B. Upon the final subdivision may being recorded. If the subdivider has dedicated an area through a dedication certificate and the dedication has been accepted by the properly authorized official, then the recording of the approved map would be the final step in the statutory dedication process. Question 3. When duly recorded in the county where the property of the judgment debtor is located, an abstract of judgment for money awarded by a court becomes A. An involuntary lien. B. A voluntary lien. C. An attachment lien. D. An equitable lien. Answer. A. A lien is a money encumbrance. In this instance, the encumbrance is placed on the property without the owner's consent and is, therefore, involuntary. Question 4. At 12 o'clock noon, Baker made an offer to purchase a single-family residence. He instructed his real estate broker not to present his offer until 6 p.m. By 6 p.m., 3 more offers had been submitted. The real estate broker should A. Ignore the other offers. B. Present all offers to the property owner in the order they were submitted. C. Present all offers to the property owner simultaneously as soon as possible. D. Wait until the seller acts on the first offer before presenting the other offers. Answer. C. The rule of agency is that all offers must be presented to the seller and let the seller make the decision as to which offer to accept. Question 5. One side of a section equals how many feet? A. 43,560. B. 5,280. C. 2,640. D. 1,000. Answer. B. A section is 1 mile on each side. 1 mile equals 5,280 feet. Question 6. Which of the following is required in a valid homestead? A. Statement that claimant is residing on the premises and desires to claim it as a homestead. B. Statement giving the exact cost of the homestead at time of purchase. C. A description of the property including a description of the improvements. D. Signature of both husband and wife. Answer. A. Any person filing a homestead is required to reside on the premises at the time that he records the homestead and to sign a statement that he desires to claim it as a homestead. The person claiming a homestead does not have to give the cost, or a description of the improvements on the property, and it can be filed by either a husband or a wife. Question 7. The broker, as agent of the seller, owes the buyer A. Only a duty to disclose any item which relates directly to the sales price of the property. B. The same fiduciary obligations he owes to the seller. C. Only the duty to answer questions honestly. D. The duty of honestly and fair dealing. Answer. D. This deals with the responsibility an agent owes the buyer when the licensee is the agent of the seller. He owes the seller fiduciary obligations, the buyer, the duty of honestly and fair dealing. Question 8. Harry owns a building in a commercial area of town. Tina rents space in the building and operates a bookstore. In Tina's bookstore, she has installed large reading tables fastened to the walls and bookshelves that create aisles from the front of the store to the back. These shelves are bolted to both the ceiling and the floor. Which of the following best characterizes the contents of Tina's bookstore? A. The shelves and tables are trade fixtures and will convey when Harry sells the building. B. The shelves and tables are trade fixtures and may properly be removed by Tina before her lease expires. C. Beck. As Tina is a tenant, the shelves and tables are fixtures and may not be removed except with Harry's permission. D. Because the shelves and tables are attached to the building, they are treated the same as other fixtures. Answer. B. Common law protects business tenants who install fixtures for their business by treating these trade fixtures as their personal property and giving tenants the right to remove them before the end of their lease. Any damage to the building due to removal is to be repaired by the departing tenant. A licensee who participates in the sale of business property should make known to purchasers what, if any, trade fixtures there are that will not convey with the building. Question 9. A real estate license is A. Constitutionally protected right of the individual. B. Privilege granted by the state. C. Right granted by the Office of the Attorney General. D. None of the above. Answer. B. Like a driver's license, it is a privilege. Question 10. If, in a transaction, the amount made as a deposit is not sufficient to cover the monetary damages incurred by a party to the real estate sales transaction, the following party could not file an action in a court of law. A. The buyer. B. The seller. C. A real estate broker acting as an agent for his principal. D. An attorney action for his principal. Answer. C. A real estate broker acting as an agent for his principal is a special agent. The broker's powers are limited to acting in the sale of the property. He has no power to file a court action for his principal.
Exam Scholar, Real Estate Edition.